So before we move to understand what is insurance waiver, we'll first try to understand what is waiver. Have you heard of the word waiver? Waiver is nothing but just a kind of a demonstration or an act. It's normally in the written form where a person try or a party in a contractual perspective intends to relinquish a legal right or a claim. This relinquishment may be voluntary and can apply to a variety of legal situations. So essentially, a waiver actually tries to remove a real or a potential liability for the other party in the agreement. Waiver where you give up certain rights is waiver. So why are we talking about can an insurance be waived? Here, normally we are talking in terms of premiums, a waiver of premium. And you know, premium is a price paid for insurance. Paid by whom? By the insured. To whom? To the insurance company. So a waiver of a premium rider is normally an optional clause that forms a part of an insurance contract that waives insurance premium payments if the policyholder becomes, say, sometimes critically ill or physically impaired. And to buy a waiver of premium rider, also there has to be certain criteria that has to be fulfilled by a person. Okay, so therefore, what is waiver again? It is a kind of intentional and voluntary act of abandoning or relinquishing a right or a privilege or a claim or a benefit. Normally, even in medical insurance, you have this waiver, and this is normally in the form of document that where a person declares that, you know, they are no more interested to be covered by a particular insurance policy. They want to waive their rights under a particular insurance policy. That means they technically want to refuse something that is already their right or their privilege. So having set the perspective, let us move forward and see what the slides have to offer us. So here, insurance waiver. Here, waiver generally implies relinquishing rights pertaining to something. And Investopedia defines waiver as a legally binding provision where either party in a contract agrees to voluntarily forfeit a claim without the other party being liable. So thereby, waiver is a voluntary relinquishment of certain rights under a valid insurance policy. What did I say? Waiver is just relinquishing of rights, giving up of rights, a right that you already possess. You say, no, I'm not interested to carry on with this particular right. I'm ready to give up those rights. That is waiver. So in insurance also, you can, or a person or the insured rather, can, you know, waive off certain rights, that is relinquish their rights. So when we're talking about insurance, there can be waiver of insurance premium by the insurance company, where the insurance company may ask the insured to pay a substantial sum as against a long-term permanent insurance policy and waive the need of paying the periodical premium. Thereby, the cost of premium will be incorporated into the total cost of the policy. Now, it may also happen that the insured may apply for a waiver on reasonable grounds, such as prolonged sickness or disability, etc., for which the proof of such a disability or medical certificate must be provided to whom? To the insurance company. And thus, a waiver of premium is a type of an add-on cover and is called a rider to the insurance policy contract. That means it would be in the form of an addendum or an annexure or an attachment to the insurance policy contract. And so we are calling it as a rider. And this particular rider would have a clause talking about waiving off or waiver of premium by the insurance company in favor of, or for the benefit of the insured, so which can be appended or attached to the insurance policy contract. Thereby, in the above context, a waiver clause will be reflected in an insurance policy or in an additional appendage or annexure as a rider to the contract that would relieve the policyholder of the obligation to pay further premiums under certain circumstances. For example, sickness of a life insurance policy holder, redundancy, if the policy permits waiver upon redundancy, that is when a person loses a job, etc. So waiver of the premium may be for a short duration until the person springs back to normal in case of redundancy, or if it is long term, it depends whether it is pertaining to medical insurance. Now, declining a mandatory insurance policy cover by an individual who is entitled to an insurance policy would also amount to a waiver of an additional insurance policy. Say, for example, B, who is A's wife, is offered a health insurance policy. So, this is an example for you for a better understanding. Now, say B, who is A's wife, is offered a health insurance policy by A's company. So, A can decline it on the ground that B already is offered a health insurance plan by her own employer. So, in such a case, B will be asked to sign a waiver form to be submitted to the insurance company through A's employer. So, this is a different kind of a waiver, okay, where she waives off her right in the husband's insurance policy because she's already a working person and she's already got an insurance policy of her own. So, a waiver is thereby an intentional voluntary act and being fully aware of the consequence of such a waiver. So a waiver can be express or implied. Example of implied waiver, that is not a written waiver, that is a waiver that could be understood by certain actions, that is implied. So if the insurer has been continually accepting delayed premiums, it cannot stop accepting delayed premiums without valid notice of its intention of henceforth negating such an acceptance. Next is the doctrine of estoppel in insurance. Now, what is estoppel? Estoppel simply means to stop. So the doctrine of estoppel forbids retracting from a promise, that is going back on a promise or a promise made or a position or a claim, especially when the promisee acts upon the promise statement to his detriment. So it is basically a defense tool in which the court stops a person. That is, a court forbids a person from moving backwards from his word or promise. There's a very interesting case on this, that is Combe versus Combe, wherein Justice Denning observed that the doctrine of promissory estoppel works on the principle of equity. However, in a contract, it should not be allowed to displace the principle of consideration. Now, what is consideration? You all know that in the law of contract, offer plus acceptance is what? Is an agreement. And an agreement which is enforceable by law is a contract. Enforceability, what gives enforceability? That means it must be bolstered with consideration. Consideration is something, say, an amount that is paid in a transaction. You buy something from the shopkeeper and you pay the amount. The amount is a consideration here. So what Justice Denning was trying to say that when it comes to the doctrine of promissory estoppel, it works in the principle of equity, but in contract, it should not be allowed to displace the principle of consideration. So in insurance contracts, the insurer is not permitted from retracting from his covenanted obligations or going back on his covenanted obligation or going away from his covenanted obligation, and that the insured has all reason to believe that the insurer would comply with the contractual obligation and has relied on the assurance and has acted upon the contract to his or her detriment. Thereby, shunning from the commitment is unacceptable, or running away from the commitment is unacceptable, and it would be construed or understood as an act that can be contested in law. Now, in Middlesex Mutual Insurance Company versus Levine, the court upheld, substantiated, and unsubstantiated the principle of promissory estoppel and maintained that for relying on the doctrine of promissory estoppel in insurance contracts, the insured must have relied upon the representation to his or her detriment. Now, estoppel, therefore, can be promissory estoppel or even equitable estoppel. For example, an insurance company cannot receive a late premium payment and then cancel the policy on the ground that So, for example, an insurance company cannot receive a late premium payment and then cancel the policy on the ground that premium was not paid within the specified period. So, yet another example is that insurance agent represented falsely to the insured about the existence of a particular insurance coverage based on which the insured purchased the policy. Then, in such a circumstance, the insurance company will be stopped from not complying with the justified claim of the insured. Next, in Emmanuel versus US Fidelity and Goa Company, the court observed that this representation must have led the insured to believe that a coverage existed. There is yet another US case, that is Professional Underwriters Insurance Company versus Freitas and Sons. The court in this case held that no estoppel when insured has never even inquired about the coverage and could not meet the threshold requirement of a promise or representation. Yet another case law, which is very important that you must quote for your exams, is Homerich versus American Chambers. The court held that representation by an agent as to the coverage under an insurance policy made before the policy is issued do not stop the insurer from denying coverage. So what happens when the defense of promissory estoppel is not available? So the next and the normal traditional course would be to deny the existence of a coverage or claim extension of coverage, as it was observed in one of the cases, that is State Farm Mutual Auto Insurance versus Hentrosa. So next is the measure of recovery. So what do you understand by promissory estoppel? Can you answer me? It simply means that, yeah, it simply means that within contract law, within contract law, promissory estoppel, it simply refers to a doctrine that a party should not retract from a promise. You should not go back on a promise. That means the law stops a person from going back on a promise. Okay, a party may, like according to the doctrine, a party may recover on the basis of a promise made when there is another party who's relied on that promise and acted on that promise. So this is what the doctrine of promissory estoppel basically speaks about. That means they are saying that a promise also is enforceable by law. And Justice Denning says that it is working on the principle of equity or equity. We call it principle doctrine of equity. That means if a person promises, that promise has to be honored. That promise is enforceable by law. Every time we cannot use the contractual principle of hardcore enforceability and stick to the concept of consideration that may be a price that is paid in a transaction. So what he's saying that it is not necessary that the doctrine of promissory estoppel, it is not necessary that it displaces or forgets consideration. It simply says that when there is a promise, it does form a part of a contract and it is enforceable, especially when another person acts on that promise. Are you understanding me? If another person acts on that promise and it has caused him some detriment or to his detriment, then the court will support and they will apply this doctrine of promissory estoppel, which enforces a promise whether it's executed as a contract or not. Now, this depends again from jurisdiction to jurisdiction. Okay. You have any questions?
Yes. You mean recovery means